Hello everyone. In this video, I am going to take two important maxims of Tort, that is Damnum sine Injuria and Injuria Sine Damnum.
The main object of law of tort is to protect a person from any damage which is caused to him due to the wrongful act of another person. That damage is caused upon him either to his person, to his property, or to his reputation. But he should have suffered certain injury because of that act. Then only he can claim compensation. But every damage is not damage in the eyes of law. If he really wants to get a compensation, then he will have to prove that due to the defendant's act, he has suffered some legal damage from defendant's act. The concept of legal damage can be better understood with the help of two maxims, which is given here. First is Damnum sine Injuria, and the second is Injuria sine Damnum. Damnum here means actual harm, loss, or damage. Injury means infringement of legal rights. Sine means without. Now I will discuss these two maxims in details. The first one, Damnum sine Injuria, means damage is caused without injury. If there is any damage caused to the plaintiff because of the wrongful act of the defendant, but there is no violation of legal right, then the plaintiff cannot bring any action against the defendant. In order to explain this, I will discuss one of the landmark case, and that is Gloucester Grammar School case. In this case, plaintiff was running a school, and nearby defendant also opened a new school, because of which the students of the plaintiff school shifted to the defendant school. In order to attract more students, the plaintiff has to reduce the fees, because of which he has suffered the pecuniary losses. As such, he filed a suit against the defendant as he has suffered damage due to opening of a new school by the defendant. The court here held that the defendant was not liable because this particular matter, this particular injury which was succumbed by the plaintiff arised because of a total competition, and there was no tort committed by the defendant. As such, the plaintiff's suit was dismissed. In the case of Cheshire versus Richard, the plaintiff was the owner of a mill. He was using water from this stream since 60 years. The defendant dug a well in his own land, because of which suddenly the water which was going through the stream in the plaintiff's mill stopped. As such, the plaintiff filed a suit against the defendant. The court held that the defendant was not liable as he has a legal right to dig in his own land. As such, he has not caused any type of injury to the plaintiff, and so he was not liable. So it can be seen that just only causing damage is not enough. If damage is caused but there is no injury, then the defendant will not be liable, and the plaintiff will have to prove that he has suffered from any legal injury. The next maxim is Injuria Sine Damnum, which means injuries without damages. If the defendant violates the legal right of the plaintiff, however, because of that violation, no damages has been suffered by the plaintiff, then also the plaintiff has a right to file a suit in the court and get the remedy. This can be explained with the help of a leading case of Ashway versus White. In this case, the plaintiff was a valid voter of parliamentary election. However, the returning officer of that election did not allow him to cast his vote, because of which he was not able to cast vote. Fortunately, his candidate won the election. Later on, the plaintiff that is, the voter filed a suit in the court to get a remedy against the defendant. The defendant took the plea that although he was not allowed to cast the vote, but his candidate won. As such, no damage is suffered by him. However, the court held that as to cast vote was his legal right and he was not allowed to exercise his legal right willfully due to the activity of the defendant. As such, he was entitled to get compensation from the defendant. The court held the defendant liable and awarded compensation. In the case of Bhim Singh versus State of Jammu and Kashmir, the petitioner was an MLA of Jammu and Kashmir Assembly. While he was on his way towards the assembly, he was illegally detained by the police, because of which he could not exercise his right to attend the assembly. As a result, he filed a suit in the court. The court awarded a compensation to him, as attend the assembly was his legal right under Article 21 of the Constitution, which he was deprived of, and as such the defendant was held liable in this case. So these two maxims helps us to determine the liability under the law of torts and also to know whether the plaintiff's legal right is violated or not. So, the plaintiff, in order to claim compensation, must have to prove that his legal rights is violated. If he is not able to prove, then he cannot claim any compensation. Legal injury is a must in order to get compensation from the court of law. With this, I conclude my video and I hope this video will be helpful for you in understanding the concept of the Damnum sine Injuria and Injuria sine Damnum. Thank you.